Welcome to this fourth seminar of the Health Law Seminar series of this academic year. I'm very happy to introduce today Erica Chamberlain, who will be speaking on who gets to decide when a person is dead. Erica is a professor and former dean of the Faculty of Law. She just actually was happily relieved of her intensive duties only a couple of months ago. At Western University, where she joined in 2005 as a professor. She was a law clerk for Mr. Justice Major at the Supreme Court of Canada, was called to the Ontario Bar in 2002. Her main research areas are torts, particularly the tort liability of police and public authorities. And her publications include Misfeasance in a Public Office, and she's also the co-author of Fridman's The Law of Torts in Canada of the 4th edition, as well as Hogg's Liability of the Crown, 5th edition of 2024. She's a researcher and advocate in impaired driving law as well, and policy alcohol-related liability and healthcare law. She's a 6-time Ironman, so is equally upset as I am about the court's war against the bikes. We will have as commentator Anthony Sangiuliano, who is a Banting postdoctoral fellow at University of Toronto Faculty of Law, where he coordinates the Tort Law and Social Equality Project, and we had a seminar just 2 weeks ago. He's also an adjunct professor at Osgoode Hall Law School and an incoming associate professor at Warwick Law School. Previously, he was a law clerk at the Ontario Court of Appeal, as well as the Supreme Court of Canada, and a volunteer researcher in the Department of Bioethics at the Hospital for Sick Children. His current research focuses on interrelations between torts, health law, equality, and bioethics. And his work has appeared in several leading law journals, and I'm sure that you want copies, you can contact him. So without further ado, Erica will speak for about half an hour or a little bit longer, and then we'll have a comment. Then I will start with some questions from the students, and then we'll open it up for the audience. For the people online, you can send in the chat any questions, but we will not unmute you. Okay, so I will check if you have any questions for the speakers. Thank you.
Thank you. As good students, you're all nicely seated at the back of the room. So thank you. Thanks very much for the invitation to come and speak to you today. I'm going to be talking about the fun and whimsical topic of how we decide when someone is dead, how we define death, and perhaps more importantly,
Can I quickly, because there's 4 more people
asking
in the way through my thing. And how do we do this? Just a second, 2 seconds, please.
I think you want to exit the presentation.
Okay. That's fine. Now we have to go back to the PC. Should have. You know how to go back to the room PC. Okay. We'll probably go back. Yeah.
Okay.
Sorry about that.
Okay, so as I said, I'm going to be talking about the fun and whimsical topic of how we define death, or perhaps more importantly, who gets to define death or decide when someone is dead. Should that decision be solely in the hands of medical practitioners? Should it be left to the courts or legislatures? Or is there room for individual patients to decide how their own deaths should be determined. And that last question I know sounds a little funny. How can I decide whether I am dead? But there are important questions here about how or whether we can accommodate religious beliefs or other matters of patient autonomy in the declaration of death. And these are questions that unfortunately we don't often think about until we have a loved one who is nearing the end of their lives. Okay, so I thought I'd explain first by how I got interested in this topic. So in my bio, you heard that I am a torts professor, and so this might seem like an odd thing for me to be researching. It happens serendipitously, as often does with these kind of research projects. So torts does have some overlap with healthcare law on issues like medical malpractice, informed consent, prenatal torts, those kinds of things. So I've dabbled in healthcare law over the years. I have taught a large undergraduate course in healthcare law, as well as the health law and policy course in Western's Master of Public Health program. And a few years ago, my faculty received a request from some intensive care neurodocs at University Hospital in London. And they wanted a law professor to join an interdisciplinary team that was applying for a big new research grant from the Tri-Council. I volunteered for that, and I've been working with that team. We got the grant, and I've been working with that team ever since. The project is called, it's up there on the screen, Neurologic Physiology After Removal of Therapy, or NEWPART for short. And essentially what we're studying is the relationship between the cessation of circulation, or when someone's heart stops, and the cessation of their brain function. So I'll talk about why that's important shortly. The observational part of that study involves patients who are breathing with the help of a ventilator and are not expected to survive. And their substitute decision maker has made the decision to remove them from the ventilator and let the patient die naturally, or let their breathing and heart naturally stop. And so if we have a family in this situation who consents to the patient being part of this NEWPART study, the team will study their brain function during the dying process. So as they're removed from life support, they study all the brain function through a means of different tests, including EEG, which looks at electrical activity, transcranial Doppler ultrasound, which measures blood flow in the brain, evoked potentials, which test brain stem function, and event-related potentials, which assess the possibility of consciousness. I've learned lots about these things from the team over the last few years. So they study the way the brain is reacting to the cessation of the pulse and breathing. And a primary rationale for this study is to support the organ donation process. Canada, like a lot of countries, has something called the dead donor rule when it comes to organ donation. In other words, you can't remove vital organs from a patient until they're dead, and if you do, you are committing homicide. So when a patient dies because they're removed from a ventilator and their heart stops beating, the dead donor rule in Canada requires that the transplant team observe a 5-minute hands-off period to make sure that the patient does not auto-resuscitate. We want to make sure the patient is dead and that they're not going to suffer from the process of having their organs removed. The 5-minute hands-off period is a conservative estimate, and the medical profession is fairly confident that patients are truly dead in that scenario. But organ donation is a time-sensitive process, and if a patient takes some time to die naturally, and then you have to wait another 5 minutes, the organs can sometimes become non-viable for transplantation. So if we could learn that the patient's brain function actually stops sooner than the 5-minute hands-off period, then we could reduce that period and make sure that more organs are available for transplantation in the circumstances. So that's how I've gotten interested in all of this, but it's not going to be the main focus of my talk today. Today, I want to focus on the concept of brain death, sometimes called death by neurological criteria, look at its history, its utility, and how it's been challenged by some patients and philosophers. And this raises issues about the relationship between medicine and the law, including when and how much deference the court should show to medical practice. It also raises broader issues about what makes someone a legal person who has rights under the charter and moral value in our society. I'll say at the outset that prior to starting this research, I, like many people, believed in the concept of brain death, both as a matter of medicine and a matter of law, and I'm pretty sure I still do. But what this research has made me grapple with are some of the broader questions underlying brain death, questions that we shouldn't just, I think, gloss over or assume away because they have implications for patient autonomy, for human dignity, and informed consent. And I think if we're going to maintain trust in the organ donation system, we need people to understand and feel comfortable about the decisions they're making on behalf of their loved ones. So if you're like me and you have generally accepted the concept of brain death till now, I just ask that you be open to a deeper exploration of some of these issues. So to get us started, let's consider the two main ways that people are declared dead. The first, which is the way that human societies have determined death for centuries, is that they stop breathing and their heart stops beating. We check to see if they have a pulse, or in the more old-fashioned kind of way, we hold a mirror or a piece of glass up to their face to see if it steams up, which is an indication that the person is breathing. So this form of death is called cardiopulmonary or cardiocirculatory, cardiorespiratory death, or death by circulatory criteria. And it's uncontroversial that when someone has no pulse and no breathing, and you're not going to take steps at resuscitation like CPR or defibrillation, the person is dead. For some people and for some religions, breath is inextricably linked to the concept of life. So you have the Latin root spiritus, which means both breath and breathing, as in our respiratory system, as well as our spirit or our soul. So that's one way, traditional way of defining death. Now, brain death or death by neurological criteria is a much more recent phenomenon dating from about the middle of the 20th century. And it rests on the premise that the brain is what coordinates all other bodily functions, including breath and circulation. So if the brain stops functioning, whether because of a stroke or under deprivation of oxygen or some massive trauma, it will no longer direct the body's functions, and the person's ability to autonomously maintain life will be lost. The heart and lungs will then stop functioning soon after. And the critical point here is the word autonomously. The reason that brain death becomes a potentially contentious issue is because medical advances that allow us to artificially maintain the function, because of medical advances that allow us to artificially maintain function of other vital organs, especially through ventilators. So machines can maintain the functioning of pretty much any vital organ apart from the brain. And when we artificially support someone's heart and lung function, we prevent the shutdown of their body systems that would normally flow after the cessation of brain function. Or as some people say, we kind of mask brain death by artificially keeping someone alive. Now, there are formal diagnostic tests that need to be performed to determine whether someone is brain dead. And these tests assess things like apnea, gag reflex, ocular functions, and response to pain. And they're set out in CMAJ guidelines that are well accepted. And usually if you have two physicians who agree that these criteria are met, then the patient is considered brain dead and a death certificate can be prepared. And this is what was challenged in the McKitty litigation, which we'll get to shortly. The recognition of brain death has been hugely important for our organ donation system. About 95% of deceased organ donors are brain dead patients. The advantage of brain dead patients is that their circulation can be maintained through mechanical means to preserve the viability of their organs and allow them to be removed for transplantation. And that avoids the risk of organ deterioration that occurs in situations of persons whose death has been brought about by a loss of cardiorespiratory function, as I mentioned earlier. And it's not a violation of the dead donor rule to remove organs from brain dead patients because they're already considered legally dead. Now, these two forms of death are interrelated. The cessation of circulation obviously stops the flow of blood to your brain, and your brain will quickly lose function. Or in the opposite direction, loss of brain function will prevent coordination of other vital bodily functions, including the heart and lungs, and the person will stop breathing. Okay, so that's a brief overview of how the medical profession determines death. What about the legal definition of death? So how many of you were surprised to learn that there wasn't a uniform legal definition of death in Canada? Quite a number of you. Okay, I certainly was when I started this work, especially when you consider how many things are affected or triggered by someone's death, not just medical things like organ donation, but legal things like inheritance, life insurance, banking, rights of survivorship, government benefits, tax, all those kinds of things. But instead of a uniform provision, which was recommended by the Law Reform Commission of Canada back in 1981, so over 40 years ago now, we have a patchwork of provincial statutes and common law rules about when death occurs. And in turn, the common law rules, which we have in Ontario, are not always well defined, often because they arise in urgent situations or because they are moot by the time they get decided. And it was the common law that was considered in the McKitty case back in 2019. The facts of that case were relatively straightforward. McKitty had suffered 2 hypoxic events, that is, loss of oxygen to her brain, and she satisfied the medical criteria for brain death. Although her cardiopulmonary function was maintained by a ventilator, her doctor declared that she was dead and prepared a death certificate. But her substitute decision makers sought an injunction to prevent her from being removed from the ventilator. They argued that McKitty's religious belief was that as long as she was still breathing, she was alive, and that removing her from the ventilator would amount to killing her and would be a violation of her freedom of religion. McKitty thus invited the courts to decide on the relationship between medical and legal definitions of death, on the level of deference to be shown to the medical profession, and on the legal status, or including the charter rights, of a brain dead patient. So I'll start just by saying a little bit about the trial decision by Justice Shaw. She reasoned that a person's death is a finding of fact, really just like any other medical condition. And she accepted the medical evidence that someone who meets the neurological criteria for death is dead. And so accordingly, McKitty was dead, both factually and legally speaking. Of broader importance, Justice Shaw reasoned that since McKitty was brain dead, she did not have charter rights. Justice Shaw listed a number of charter rights that seem to require active participation by the subject, things like freedom of expression, the right to vote, language rights, and so on. And she continued that McKitty, quote, with a lack of capacity for consciousness, lack of capacity to breathe, and no brainstem function, end quote, is not able to exercise any of these rights and freedoms. Now that statement could be a little troubling if we equate personhood with things like consciousness or even the capacity to breathe. We run the risk of excluding a lot of individuals from charter protections. For instance, as I'll discuss shortly, patients who have unresponsive wakefulness syndrome, which is the more humane term that replaced persistent vegetative state, have only minimal or covert consciousness, but nevertheless, we say that those individuals are persons who have protections under the charter. Patients may also be comatose or may require assistance with breathing for a period of time, and they still have charter rights. And even patients who have weak heart and lungs and whose heart and lungs can't function on their own and would die without the use of a ventilator are still considered alive and require the consent of a substitute decision maker before they can be removed from life-sustaining treatment. So we need to be careful about saying that you only have charter rights if you can exercise them. Justice Shaw also reasoned that it's not for the courts to engage in a theological debate about when life begins or when it ends. And to the extent that she was suggesting that the legal definition of death should be left to the legislature, I think I completely agree with her. But the fact is that the courts have already, whether they like to admit it or not, engaged in these discussions. In torts, for example, which is my field, Questions about prenatal injuries clearly entail a decision, or a discussion at least, about the legal rights of a fetus. And the courts have ruled that until a baby is born alive, it is simply a part of a pregnant woman's body and has no rights of its own. Nor does a physician owe an independent duty of care in negligence toward a fetus. So even, excuse me, even when not expressly stated, these discussions involve questions beyond mere biology. They involve questions about patient autonomy during pregnancy and the right to make decisions about one's own health. And they clearly subordinate the fetus in these discussions. So there is precedent for the common law courts engaging in discussion about the moral status of a fetus or about when life begins, something that they've settled in Canada through the Born Alive Rule. Excuse me for a second. Okay, finally, Justice Shaw was persuaded by some of the practical implications that would flow from a decision that people could essentially opt out of the neurological determination of death. And in particular, she suggested that this would be highly disruptive to our organ donation system, which relies heavily on donations from brain-dead donors. These implications would need to be carefully considered when deciding on a modified or essentially customized legal definition of death. So in the end, Justice Shaw would have upheld the doctor's decision and permitted the death certificate to stand, but she suspended the application of her decision while there was an appeal. Which brings me to the Court of Appeal decision, which I think is a pretty good read, even if you're not, whatever your feelings about brain death might happen to be. There are a couple of things I want to highlight. The relationship between accepted medical practice and the law and the legal status of a brain dead patient, particularly with respect to charter rights. After the appeal was argued, but before the court delivered its opinion, McKitty's heart stopped beating, and so she was declared dead by the more traditional circulatory criteria. That made the Court of Appeal's decision moot, but it went ahead at the request of both parties. The court upheld Justice Shaw's decision on the basis that the common law had already accepted brain death as a form of death. Nevertheless, the court was clear that the law did not have to defer to accepted medical practice, and that if the medical profession determined some new means of concluding that a person was dead, the courts would not necessarily have to accept it. So in terms of whether the law should defer to medical practice on the definition of death, the court answered with a clear no. And the key portion of Justice Miller's opinion is up on the screen. I think it's obviously a key paragraph in this decision. He said, the determination of legal death is not simply or even primarily a medical or biological question. The question of who the law recognizes as a human being entitled to all of the benefits and protections of the law cannot be answered by medical knowledge alone. Facts about the physiology of the brain dead patient are needed to determine what obligations are owed to the brain dead patient. But the inquiry is not ultimately technical or scientific, it is evaluative. Who the common law ought to regard as a human being, a bearer of legal rights, is inescapably a question of justice, informed but not ultimately determined by current medical practice, bioethics, moral philosophy, and other disciplines. So in this paragraph, Justice Miller, I think, did a pretty good job of explaining the complexity involved in the legal determination of whether someone is dead. While the courts will certainly take into account what the medical profession has to say, that is only one part of the equation. For people of many different religions, cultures, humanistic beliefs, and otherwise, death is much more than a biological fact. We have and will continue to debate its meaning for centuries. Now, when it came to the charter, the Court of Appeal disagreed with Justice Shaw's analysis in several ways. First and most importantly, the court held that the discussion about whether the neurological determination of death violated McKitty's freedom of religion had to occur prior to deciding whether she was legally dead. Justice Shaw, by accepting McKitty's death before analyzing whether she had charter rights, assumed away the very question that was in dispute. The question was whether McKitty's charter right to freedom of religion was infringed by declaring her to be dead even when she was still breathing. Second, when it came to defining that charter right, the Court of Appeal explained that the question is not about protecting what Justice Shaw had referred to as the focal point of McKitty's worship or her soul, but about the divine command accepted by her religion and others that you should not intentionally kill anyone, including yourself, and that includes through the deliberate withdrawal of life-sustaining measures. This is a belief that, if sincerely held, has a sufficient nexus with religion to invoke the charter. Ultimately, the Court of Appeal explained that they didn't have a sufficient record to determine the charter issues, but they seem to invite courts to consider them on a more robust record in the future. So hopefully future litigants will come better armed, not just with facts, but with arguments about the religious beliefs in question and how those religious beliefs might be accommodated in our legal system. So that's McKitty. Now I'd like to turn our discussion to a couple of broader questions. First, when do we think that someone ceases to be a rights holder under the charter? Second, is there a way for us to accommodate religious belief without creating major disruptions to our organ donation system and healthcare system generally? And third, how can we resolve these questions in a way that gives clear guidance to healthcare practitioners and maintains trust among patients and their families? So we've got a mix here of highly philosophical and moral questions and more practical ones. I'm going to start with the philosophical or moral questions. So what level of biological functioning is considered sufficient for someone to have moral or legal value in our society? Consider that brain-dead patients, if assisted by ventilators or other supports, may still be able to absorb nutrients, excrete waste, and fight off infection. And it's not until those supports are removed that their vital organs will stop functioning and they will ultimately stop breathing and proceed to biological death. So is that persistence of essential biological functioning enough to make them a bearer of at least minimal legal rights? Next, does the act of a physician declaring a person to be dead, and I'll say declaring in quotation marks here, have the effect of someone removing those legal and moral rights, even though the biology at that moment doesn't change, right? So if you have a physician who says, I now declare you to be brain dead, what does that change in the moment in that room, legally speaking, biologically speaking? Should we have some requirement in those situations or some role for substitute decision makers for removing that person from life support? Now compare this, as I said, to the situation of patients whose heart is too weak to perform on its own and who are similarly being kept alive with the support of a ventilator. In those situations, we uncontroversially consider the person to be a bearer of legal rights. And the substitute decision makers have to consent to them being removed from a ventilator and letting them die. And this is a decision that families make for their loved ones on a fairly routine basis. I did for my own father back in 2018. They decide that it's in their loved one's best interest to allow them to die. So you can understand then why families of brain dead patients might have a bit of confusion. Physicians can provide a medical explanation of brain death. They can explain that the patient's brain is no longer functioning and is incapable of coordinating bodily functions. More metaphysically speaking, they can even say something like, your mother is already gone. But their loved ones look at the body and see that the skin is still warm. They see that the person is still flushed. The person may be taking on nutrition. And yet here, in this situation, we say that there's no decision to make about removing the person from life support because the patient is already dead. And as I discussed in my case comment on McKitty, which I think at least the students have, some philosophers argue that it's misleading in these circumstances to insist on the fact that someone is dead and thereby leave their loved ones in a situation where, formally speaking at least, they don't have any say in what happens next. Now, I'm not suggesting that physicians are this cold or belligerent at all in these circumstances. They will, in almost all cases, provide the family with ample opportunity to say goodbye, and at least within a certain window, will not rush them from taking the patient off life support. But cases like McKitty show that conflicts can happen when the substitute decision makers have different views. And the Court of Appeal decision in McKitty concluded that the law doesn't have to just defer to medical practice. They said it's a question of justice, not just physiology. Now, I think we can gain some insight from the Supreme Court of Canada's 2013 decision in Cuthbertson and Razzouli, which also examined the relationship between medical practice and legal decisions. The patient in Razzouli, have you studied Razzouli at all? Some? No? Okay, I don't want to repeat it if you have, but I will do it now. So the patient in Razzouli had unresponsive wakefulness syndrome with no realistic possibility of recovery. He was being kept alive by virtue of a ventilator and artificial nutrition and hydration. His physicians advised that there was no medical benefit to keeping him alive and that keeping him alive may actually cause him harm. But for a variety of reasons, his wife and substitute decision maker refused to consent to the withdrawal of life support. And among those reasons was that as a devout Shia Muslim, he would not have consented to ending his own life. Now, Razzouli was largely a case about Ontario's Healthcare Consent Act 1996, and specifically whether removal of life-sustaining, I can admit this person came on. Whether removal of life-sustaining treatment was a form of treatment, quote unquote, that required consent under the Act. And the majority decided that it was a form of treatment. And so Razzouli's physicians could not remove him from life support without the consent of his substitute decision maker. If you're familiar with the Healthcare Consent Act, you know that substitute decision makers have to make decisions about consenting to treatment based on the patient's best interests. And there's a list of factors that they have to take into consideration. And these factors include medical considerations, like whether treatment is likely to improve the patient's condition, whether the benefit of treatment outweighs its potential harms, and whether the patient's condition is likely to deteriorate without treatment. But it also includes wishes expressed by the patient while capable, as well as the values and beliefs of the patient, which includes their religious beliefs. So I want to highlight a few things about Razzouli. First, I think it's critical that the majority concluded that withdrawal of life-sustaining treatments is a form of treatment that requires consent under the Healthcare Consent Act. The dissenting judges disagreed on this point and concluded that the withdrawal of life support was not a form of treatment. The implication is that physicians would be able to withdraw life support whenever they concluded that ongoing treatment was medically futile, without the consent of the substitute decision maker. This, I think, gives too much power to physicians and runs the risk of some fairly traumatic conflict between physicians and family members at the end of someone's life, including when someone is comatose like Razzouli, or presumably also those with weak hearts or circulatory systems. Second, the majority in Razzouli stressed the express purposes of the Healthcare Consent Act, which include enhancing autonomy for those for whom treatment is proposed. So the Act promotes patient autonomy through measures requiring informed consent, respect for wishes expressed by a patient while they're capable, and as I said, the list of factors that have to be considered with respect to a patient's best interests that include not only their medical best interests, but also their values and beliefs. So consider your own ability to make treatment decisions. When it comes to capable adults, both in the common law and by statute, we say that it's their decision whether to give or withhold consent to treatment. If you are capable, you alone get to decide what treatments you want to undergo, and you can base your decision on whatever factors are most important to you. If you decide that a given form of treatment is contrary to your religious beliefs, you can refuse consent. You might even refuse consent because you're afraid of a particular treatment or the pain it might cause. And physicians and others, including your family members, may consider your decision to be foolish or irrational. But the point of our law is that it is your decision to make. And the Healthcare Consent Act attempts to maintain as much of this autonomy as possible for patients who are incapacitated. So if you've made a prior expressed wish while capable, that wish has to be respected, even if physicians or family members disagree with it. And even if you haven't expressed a wish, but your substitute decision maker has good reason to believe that you would oppose certain treatment on religious grounds, that's something that they have to consider when making treatment decisions on your behalf. Importantly, the majority in Rizzulli agreed that a person in a state of unresponsive wakefulness still had best interests that had to be considered, and that his autonomy had to be respected as much as possible in the circumstances. They did not simply assume that absent consciousness, he had no legal or moral personhood, nor did they show blanket deference to the medical practitioners. While the court declined to decide the charter issues raised by the parties, it's implicit in Rizzulli that patients with unresponsive wakefulness syndrome are still legal persons. So, someone who is unresponsive and who will not recover is still considered a legal person. So that means your capacity to exercise your legal or charter rights is not what makes you a legal person. We also know that infants or people with severe dementia or other illnesses that undermine their capacity to make their own decisions or be held responsible for criminal acts are still legal persons. So your moral agency isn't necessarily what makes you a legal person either. And as I mentioned, someone with a weak heart who will die without life support is still considered a legal person. So where do we draw the line? I don't personally have the answer to that question, but I agree with the Ontario Court of Appeal in McKitty that this is a conversation we need to have as a community, informed by medical practice, absolutely, but also by religion, philosophy, and other legal values that we have already accepted, like patient autonomy and informed consent. Okay. Moving on, I'm interested in our discussion in your thoughts on whether we can make room for a religious exemption to death based on neurological criteria, as might have been applicable in McKitty. There are precedents for such exemptions, as in New Jersey, and I have the provision on the slide there. So the United States has had a uniform legal definition of death, which includes brain death since the early 1980s. But there is an exemption in the New Jersey statute if the patient is someone for whom this form of death determination will violate their freedom of religion. Okay, so we do have precedents for this. Do you think we could accommodate that in Canada? Evidence suggests there would be a relatively small minority of the population who would request an exemption like this, typically those of some kind of Orthodox faith. For some people, it's a higher power that decides whether we live or die, and it's not for human beings to take those matters into their own hands. And that can be a fundamental belief about humanity's relationship to the divine. So we could allow these individuals to make decisions about their death. When it comes to decisions they make while they're alive and capable, we certainly allow people to make decisions based on their religious beliefs. And their substitute decision makers have to take those things into account when making healthcare decisions. So why not include it when we're talking about determination of death? There could be good reasons, but we'll leave that to discuss. Assuming that forcing these people to accept a declaration of death by neurological criteria is considered a violation of their freedom of religion, what would our Section 1 analysis need to consider? And perhaps Anthony can speak more on this because I'm not a constitutional law professor, so these are broad sweeping generalizations that I'm going to say here. In terms of government objectives, I suppose we could think of the need for medical certainty. That's important. The importance of the organ donation system, and maybe to a lesser degree, the allocation of health resources and the need to minimize medically futile treatment. We saw that Justice Shaw was concerned about organ donation in McKitty, and I think this is a legitimate concern, a pressing concern for government. At the same time, we need to appreciate that a religious exemption is not likely, I think, to have a major practical impact. Less than 1% of deaths in Canada occur in a hospital setting that would even allow for organ donation from a brain dead patient. In Canada, we have a total of about 750 deceased organ donors on an annual basis. And as I said, we'd probably be dealing with a fairly small minority of religious faiths. And practically speaking, if you're someone whose religion dictates that a person is alive, as long as they are still breathing, and you don't want to consent to your loved one being removed from a ventilator, then you're probably going to come into conflict with medical practitioners would tell you that your loved one is already dead and they want to start removing organs for transplantation. I think that's going to create a situation of mistrust and is unlikely to make you want to donate to organ donation, donate your loved one's organs. And even worse, if you're in a province that has opt-out legislation for organ donation, then at least in theory, the physicians could go ahead and start the process of removing organs against the family's wishes because the patient has already been declared brain dead. But in the long run, I think not having some kind of consideration for religious belief actually could undermine the organ donation system. And so I think allowing a small percentage of people to reject the declaration of brain death is not going to have a major impact on our organ donation system. Most people will likely continue consenting to organ donation because it allows them to gain some meaning from what might otherwise be a tragic death. And if we consider minimal impairment under the charter, it could be beneficial to have some kind of tailored religious exemption. Given the very personal and fundamental nature of death, it's unlikely that insisting on a universal acceptance of brain death will be considered minimal impairment, but I'll leave Anthony maybe to comment on that. Okay, now you may be concerned about recent movements to reject certain aspects of medical practice. This is something that I was thinking about, whether that's opposition to vaccination, to fluoride in water, or pasteurization of milk. Take your pick, they've all been in the news recently. And the underlying argument of these movements is that people should have more freedom of choice when it comes to their bodies and their healthcare decisions. So there might be a worry that if we create an exemption to the declaration of death by neurological criteria, there's going to be a growing number of people who want to seek that exemption because of this kind of mistrust of medical authorities. And I don't want to discount that as a concern. Maybe, again, that's something we can discuss. And that brings me to my last point, which is the implications of all this for medical practice. It's one thing for lawyers or law professors to pontificate about the legal definition of death, but medical practitioners are faced with these life and death scenarios on a regular basis. They have very real concerns about their own ethical and legal obligations, about the success of the organ donation system, and about the allocation of increasingly scarce health resources. Now, I think that medical practitioners, like patients and their families, would benefit from a clear and uniform legal definition of death across the country. I think this is better provided in legislation rather than the courts, because legislatures can gather and incorporate the views of various stakeholders. This may or may not include an exemption for a religious exemption for the declaration of brain death. But a uniform definition would minimize the risk that medical practitioners are going to be pitted against families in courts in what are likely to be time-sensitive and emotionally charged situations. And physicians could then adjust their practice to ensure that they're providing families with the opportunity to provide informed consent with respect to the removal of life support and potentially organ donation. Of course, this may mean that more people are kept on life support for longer than would otherwise be the case. But again, I think this is likely to be in a small number of cases. And if physicians truly believe that substitute decision makers are not acting in the patient's best interests, then they can use, in Ontario, the Consent Capacity Board's dispute resolution processes in that respect. So to conclude, I think I probably raised more questions than I have answered, but I want to go back to the title of my talk, which was who gets to decide when someone is dead? Should it be medical professionals who are best informed about the biological processes? Should it be patients or their substitute decision makers who may have religious beliefs about what it means to be alive or dead? Or should it be adjudicators like the courts or the Consent Capacity Board who can weigh competing considerations? And how much should the courts defer to accepted medical practice in making these determinations? Is death just a finding of fact like any other medical condition, or is it something bigger than that? Additionally, which of these options is most consistent with other values that we've accepted in the law, like patient autonomy, dignity in the dying process, informed consent, and a patient's best interests? And how do we account for practical concerns like our organ donation system and the allocation of health resources? Are those considerations even relevant to the determination of death? And can they outweigh our other values? So the more I think about these issues, the more questions I have, but I look forward to our discussion and hope you will all enrich my understanding of these issues too. Thank you.
Anthony?
Oh, were you wrong for that? So thanks very much, Erica, and I think echoing a couple of the comments you made to start, this was a really kind of informative paper for shedding light on an area of law that was pretty obscure, I think, to most of us before the legal definition of death, and so I learned a lot from engaging with it. Thanks, Trudeau, for inviting me and turning me from an audience member in the seminar to a speaker. I'm afraid I'm probably going to also just raise more questions at the end, maybe instead of answering them. So there are three things that I want to kind of contribute to the discussion about Erica's talk. So the first, I think there's a running through line, both through maybe through some of the legal decisions, but also in your argument, Erica, that legislatures are better than courts at resolving these really difficult, profound moral questions about death. And it would be preferable if we had legislative intervention. And you see, like in the McKitty litigation, the Court of Appeal was kind of reluctant to even decide questions without an adequate factual foundation. So it's something I think, it's easy to look at this claim and raise a worry that are we devaluing whatever important contribution courts are able to make to defining these sorts of questions. And not only that, but developing the common law, like for example, the common law of what counts as death, what counts as dying, in a way that advances fundamental social values. The other point is that it's potentially puts courts in a kind of awkward position relative to legislatures, a kind of supervisory position. So checking to see post facto whether legislative definitions of death are compliant with the charter, which raises all kinds of, the counter-majoritarian difficulties in constitutional law that we're familiar with. There's a trend in recent constitutional theory towards thinking about the relationship between courts and legislatures as more collaborative and working together in a way that to implement fundamental social values rather than asking one institution to take the lead and another to kind of check to see whether that institution is doing well. So that's just, you might have those worries. I've kind of tried to explore them in some of my work, but here, instead of trying to substantiate them, I'm not going to ask you to take my word for it. I'll just say I think the Supreme Court actually has rejected the view that in a lot of cases involving the implementation of charter values, the legislature is best suited for that as opposed to courts. So one is in administrative law, the interaction between administrative and constitutional law. So here's a quote I dug up from Slate Communications in Davidson, 1989, if you remember from constitutional law. And this was it was the first case where the Supreme Court had to consider how are we going to adjudicate claims that an administrative tribunal has violated the charter. And Chief Justice Dixon in that case said, look, we're going to apply, we're going to treat the decision as if it were a legislative decision. We're going to use the same old analysis for whether a law violates the charter as compared to whether an administrative decision violates the charter. That is, breach of the charter, section 1, go to section 1 of Oakes. Instead of applying reasonableness review, instead of applying standard of review from the common law of administrative law. And what Chief Justice Dixon said in that case is that the common law of reasonableness review, quote, rests to a large extent on unarticulated and underdeveloped values and lacks the same degree of structure and sophistication of analysis. I think that sort of critique might mirror the claim that questions about death, which are inherently value-laden, should be left up to legislatures too. But of course, as we know, the Supreme Court has not followed suit. They, in the Doré case, recognized that reasonableness review does have the kind of robust framework to be able to incorporate charter values, which has led to another whole host of debates. But it seems like the ability of the common law to integrate these fundamental moral concerns is recognized here and maybe should not be discounted either when it comes to defining death. Another area is police powers. So ever since the Supreme Court created the RIDE program for stopping drivers to determine their blood alcohol level on a random basis, they've been defining a whole host of common law police. It was the Supreme Court that created powers like strip searches, I said RIDE, arrest, incident to detention, investigative detention. It wasn't the legislature. And as over the years, a lot of commentators have said, look, you're not very good at it, courts. You're not very good at defining police powers. They're too big. You're just not very good at balancing the kind of values that are involved here. Privacy, liberty versus values of crime control and so on. And in a case called Kang Brown, which had to do with the validity of sniffer dog searches, they recognized the power at common law for the police to use sniffer dogs to search for drugs. I think it was Justice Binney in that case said, look, we've crossed the Rubicon. That was the language, we've crossed the Rubicon. We're already using the common law to balance these values. We're not just gonna leave it up to the legislature. And so I think the question is death special in this way? Does the Supreme Court have it wrong in those cases? And also, should we not follow those kind of bad exemplars? That's the first question. The second, and this is the one that's really gonna, I think, raise a lot more questions. This point about accommodating religious beliefs when defining death, and this, I think, you can think about this from the perspective of the common law or if it's in legislation. So here, I think the protection of religious freedom functions as what Professor Ben Berger at Osgoode calls a pluralist inclusion into the law. So Berger thinks that a lot of areas where the law protects religious freedom they provide a kind of channel through which values of pluralism and kind of get injected into the law, and that secular law has to be able to reckon with what seem like deviations from mainstream moral beliefs, for example. So I think that when we're talking about accommodating religious beliefs in the definition of death, we're also looking at a potential pluralist inclusion. A variety of beliefs can change the way that maybe secular or non-religious beliefs view death. But the thing is, like all pluralist inclusions at every area of law, there has to be a limit to pluralism, or it seems like there should be a limit to pluralism. Right, so it doesn't seem to be the case that we should allow the definition of death to be kind of dictated by just any belief about what counts as death. And so this issue becomes a little bit more stark once we see that if we should protect religious freedom when it comes to defining death under the Charter, what about freedom of conscience, which is also a Charter protected right? So non-religious beliefs about death, which now you start to see like proliferation of potential beliefs that need to be accommodated, but it starts to get absurd. So I think it starts to get absurd. So let me give you a couple of hypotheticals where it seems like we wouldn't accept this kind of this particular belief about death. So one is a belief that imagine someone holds a belief that death can occur before brain death. Okay, so that kind of might seem, how could somebody possibly believe that? Some philosophers develop this idea called a transformative experience, okay, in the philosophy of personal identity. So some examples of transformative experiences people might have in their life is falling in love, having children, experiencing trauma, surviving a near-death experience, which I guess maybe circular, what counts as a near-death experience, being diagnosed with a terminal illness is a transformative experience. The idea is that it fundamentally reshapes one's personal identity to the extent that you can't really call yourself the same person before and after having the experience, right? So I was just, when I went skydiving, I just became a different person. I decided I was going to take more risks in life that allowed me to experience all of these things that I never would before. My values were fundamentally shifted. And so imagine somebody says, look, I really want to kind of celebrate my change in personal identity after going through this personal experience. Doctor, can you please write me a death certificate for what happened to me before going into that plane and skydiving, before falling in love? The doctor, I think, would not accede to this request. It seems absurd to say that belief about death should be accommodated. But here's another one. What about a belief about death imagine somebody believes that death can occur after cardiopulmonary death. Okay, so they might believe that someone might take an extreme physical view of what a person is and say, look, there's no death until, as long as the body is physically present on this earth, maybe once it decomposes, that's when death occurs. And so you can imagine a person who holds this belief trying to like attain immortality by taxiderming themselves and saying, look, my body's still here. It doesn't matter that it's not functioning. That's not what I believe death is. I haven't died until the body has decomposed. There is Jeremy Bentham, a philosopher you might have come across in your studies, who did believe this, and he is currently taxidermized in his office at University College London. So some people could take this view. And again, I think if somebody came across Jeremy Bentham's taxidermized body, if a doctor came across it, they would have no hesitation in writing a death certificate. Right, so how do we explain why these beliefs are absurd, why they shouldn't be accommodated? I'll just make a conjecture. The conjecture, it seems that both of these types of beliefs kind of exceed the outer bounds of what counts as an acceptable belief about death. Right? On the one hand, it kind of says death occurs, the view that death can occur before brain death seems to put death too early in someone's life cycle. And the belief that it can occur after cardiopulmonary death seems to put it too late, right? And so if you think that, like I do, that these hypotheticals establish limits on beliefs that should not be accommodated, what I think we should conclude is that medical science seems to be setting the outer boundaries of what is acceptable. On the one hand, brain death at the earliest, cardiopulmonary death at the latest. And if that's true, then maybe as lawyers or as value thinkers, as Justice Miller might say, we are deferring to the medical community, at least in that respect, but allowing for variation within belief as long as they comply with those limits that we set. So I guess the question is, do you agree that those are absurd beliefs? So what do we make of those requests for accommodation? And the third, this is the last thing I'll mention. So I want to just ask the question of who would have standing to challenge, like let's suppose there is a legislative provision, who gets standing? So we've been sort of operating under the assumption as the charter rights of the person whose death is in question, right? That on behalf of whom the charter challenge would proceed, or on behalf of whom charter values must be invoked in the common law, right? So there's this puzzle. You can't make the claim that those people don't have charter rights. Because it begs the entire question at issue. But we can actually just solve this whole problem by saying, what about the family members? Do family members have standing to be able to challenge the validity of a statute? It seems like family members have a legitimate interest. So the standing rules in constitutional law, there has to be a genuine interest on the part of the challenger in the issue. And it does seem like the family has a genuine interest. A lot of these cases involve the family giving evidence about what counts as the deeply held religious beliefs of the person whose death is in question. But here we're saying, look, it's their interest not in explaining what the patient believes, but their interest in how their family members are treated. Does that count as a constitutionally protected interest? I think it might. In private law, we recognize standing of family members whose when their dependents, when the person they depend on is killed by a private wrong, they have standing for certain kinds of damages in limited circumstances. I was also thinking about the GJ case. This is a case where the Supreme Court said that child protection proceedings, when a child is removed from a parent's custody, the parent's security of the person interests under Section 7 are implicated. So I wonder if something like a person's religious belief in how their family members are treated might give them standing to challenge these laws. And at common law, if we take, this goes back to the sort of my intuition or my inclination to prefer the common law in addressing these questions. Like this puzzle doesn't arise at all, because it's possible for charter values to be invoked either to shape the common law or in some other context, where those values are kind of pertain to people who don't have standing before the court. Okay, so this was at issue in a recent Supreme Court of Canada, another administrative law case as well. But if we accept that the values of family members matter, even if they're kind of not parties to a proceeding before the court, then developing the common law might have to take into account their religious freedom about how their family members want to be treated. Right, so I'm also happy to speak a little bit about the section 1 question, which you invited me to do. I guess that will be the last thing I'd say. I think the only thing I wanted to mention there was that the Supreme Court has been pretty clear to say that like a section 1 analysis shouldn't be understood as an accommodation analysis in the way that we might think of it under human rights law. So, you know, there's the Vegetarian Brethren case where the court says this group of this religious community doesn't want to have their photograph taken, and that might they want an exemption from driver's license laws that require their photograph to be taken. We shouldn't think of this as them asking for an exemption, but we have to ask whether the general rule, right, that everybody has to get their photograph taken is preferable to having a rule with some exemptions, right? So we might take the same approach here as well. Okay, so thanks. Again, probably raise more questions than answer. Thank you.
Thank you. If you,
I'll-
the two of you want to come there. So just to add on your comment about Jeremy Bentham. So I discussed it in a class on treatment of the human body. Apparently, it was a myth that Jeremy Bentham would sometimes be rolled into the faculty council meetings. And they would say, they would write in the on the agenda or on the minutes of the meeting, Jeremy Bentham present but not voting. I'll open it up for some questions. I'll start with some student questions. I have one question already online, and I will note anybody else who wants to ask a question. So I'll start with Stanley.
Thank you, Professor, for your talk.
If you should try to speak up as loud as possible.
Thank you for your talk. I think one key takeaway for me is that obviously the legal definition of death is even more value laden than the medical definition. And you also suggest that for that reason, more or less, legislators are in a better position to debate questions about the legal definition than courts, because they can engage with religious groups, ethicists and medical experts and so forth. But I wonder if you would say how much of this perceived difficulty with debates about what the legal definition of death would you say really arises from a perceived need to have a uniform definition that applies to everyone under our jurisdiction? Because this idea seems to be what's really in tension with the thought that when people should be declared legally dead may also depend on individual religious beliefs. So if you are to say that there's no genuine need to adopt a uniform legal definition of death, then would you say that a lot of the perceived difficulty with defining death legally actually goes away?
I think when I think about, I guess when I use the term uniform legal definition of death, I'm more referring to uniformity among jurisdictions, right? Because right now we have common law in some provinces, we have actual definitions in some provincial legislation, and we have some provincial legislation which just says whatever accepted medical practice is, that's our definition of death, right? So when I refer to uniformity, I'm more concerned with uniformity across jurisdictions as opposed to uniform definition that applies to every single individual. So I think we could have a uniform definition across the country that also includes some kind of religious exemption, for example.
Yeah.
So that's a little difference in terminology, I guess, that I would.
Okay. Fine.
Yeah.
Okay. So Manreed.
Yeah. I guess my question is, how do you think that legislators have dealt with the definition of death in the context of MAID, if that's something that you can possibly speak to? Because that there it would be legislators using kind of those values to determine those questions.
I'm not an expert, Professor Lewis is more of an expert than I am on medical assistance in dying and how that relates to the definition of death. I can't say I have a lot of expertise on that, but. comment.
So the question is whether it's a reflective of a larger potential problematic potential. So I was actually going to ask a question that is somewhat related to it, and so I'm still struggling. I don't have an immediate answer, but one of the things that certainly comes up in the medical assistance and dying debate is the role of the courts. So which is slightly different here, but which is also in your paper questioned as, okay, we have to rely on doctors to decide. So we currently have an injunction case in BC where some argue that the courts have no role to play in any of the medical assessments about whether somebody is eligible for medical assistance in dying. And there have at least been 2 precedents where this was stated as well. So it's related to MAID. It's not an answer to your question, but I had that as a question as well. Like, how do your arguments apply in the context of the medical assistance and dying debate? Because I think it's too easily stated, oh, physicians decide these things. Anthony, yeah.
I also wonder whether, given like what Justice Miller's concern was in McKitty was about how religious beliefs understand the taking of life or the allowing to die. One way that these sorts of concerns might come into MAID is religious exemptions for practitioners who may want to have exemptions from like professional guidelines about whether to refer someone for MAID. So there has been, I think that Court of Appeal case might have been also decided the same year of McKitty about whether it was reasonable for the College of Physicians to deny that sort of exemption to doctors whose religious beliefs, Catholic religious beliefs, got in the way of making referrals for MAID. So that's certainly one connection I think that could be made between these debates as well and MAID.
And maybe in addition to more directly with regards to your question as well. So I think it's clear also that in the medical assistance and dying debate, people too easily make the claim, oh, this is just a medical decision. And these are things that the doctors decide. And while ignoring the kind of the loaded important questions about what does dying mean? What is intolerable a concept like intolerable suffering? How do doctors determine that? Because yes, it's based from the perspective of the patient, but still doctors are asked to exercise judgments that are related to fundamental questions that are not medical, but that are presented as, oh, this is a clean medical question that can be answered by physicians. So I think your question is very valid in that perspective.
And then all the questions about autonomy, right? And about, you know, your ability to make decisions about your own life and death is I mean, that's a huge part of that discussion.
So Emily?
So I know that you said the legal and medical definition of death should maybe be or can be separate. I guess I was wondering whether you believe that the definition of death legally should evolve as scientific advancements evolve, or what your thoughts are, whether the definition should still remain very.
So I would totally support it evolving as, as informed by medical practice and medical knowledge. I think that's really important for the and that might be an argument for the common law too, in that there can be that kind of evolution. And I guess I'm just siding with Justice Miller a little bit on the idea that we can take that into, take scientific and medical evolution into account, but don't necessarily have to accept everything that science has to say. And there are other, I'm a torts professor, so I keep thinking of other torts examples, but like with Sadati and Moorhead, and the idea that, we don't have to just defer to what the DSM says about, psychological harm or psychiatric illness. We can, legally speaking, we can decide that damage is something different. So we can take that into account, but we're not necessarily bound by it. And I think we don't want to kind of consider ourselves just beholden to whatever the medical profession has to say.
I wonder whether, sort of thinking about that question as well. I think there are 2 ways you can envision medical science altering the sorts of parameters of these debates. I think one might be just shedding new light on when brain death occurs and when it doesn't. That could be one, or shedding new light on when. I think there was a case involving a beheading, but the heart was still pumping. right? So like, we can, medical science might shed light on what counts as cardiopulmonary death. But will medical science ever, will technology advance in a way that gives us an entirely new conception of death, like a third category? And like, I'm not sure, I'm thinking about things like Neuralink. And if you're able to fully like download your brain into a machine, and the body just gets left behind, what do we say about that? And these are fantastical debates, but a lot of things that we thought were fantastical became reality once technology advanced sufficiently. All kinds of stuff about artificial intelligence happening now. So that could be a second one, entirely new category and we can't really see right now.
I did see a headline a couple of weeks ago that said like something about scientists discovering a third state that was not life or death, but something else, and it had to do with cells growing in dishes and things like that. That was kind of neither life nor death. But so who knows where medicine will take us.
Ali?
In your case commentary, you argue for clear legislative and uniform definition of death rather than Canada's current reliance on a mix of common law and statutory provisions that vary, suggesting that legislators rather than courts or the medical community alone better equipped to address complex questions surrounding what constitutes death. Given that a definition of death is not limited to medical viewpoints, but also incorporates broader ethical, cultural, religious, and philosophical considerations, how do you think legislatures will ensure these diverse considerations are meaningfully incorporated into their determination?
It's a really good question. It puts a lot of faith in our legislators, right? So I guess, I try to think of legislative process and at least having debates and committee hearings and things like that, where at least those viewpoints can all be shared and considered. Whether they ultimately come up with what we think is the right decision, I'm not sure we can necessarily be confident in that. But I guess, and I'm a huge fan of the common law, so like I get your criticism that, like we don't want to completely subordinate the courts. But I guess in comparison to the courts, I feel like just the evidence that's going to be before a court is rarely going to be the kind of evidence or debate that a legislature is going to be able to have, right? And it's typically, one judge or a handful of judges who are deciding these kinds of things, and they're very much at the mercy of what the parties bring before them. So I think legislatures at least have the opportunity to have a broader conversation. Whether they end up with the right mix of perspectives in the legislation, I'm not 100% sure, but I guess we have to have faith in that kind of debating process.
Anthony?
Well, I think that, again, I only hinted at it in the remarks I made, and I think it's also emerging from our discussion here, is that maybe we shouldn't think of this as a kind of exclusivity question or an either or question. Like, why should it be just courts or just legislatures? It can certainly be both. If you have a common law definition of death as well as a legislative one, you're going to have questions about how the common law interacts with statutes arising a lot. But you can kind of reap the benefits of both the fact that courts are not going to be because of their independence, aren't necessarily going to be beholden to whatever prevailing political views there are at a given time when defining death, but also they're at a deficit in gathering knowledge in a way that legislatures are. So again, collaboration and bringing multiple perspectives to the table, I think, is at least just a good shift in framework for thinking about these issues.
Okay, Bonnie?
I think my question has been kind of
It
answered.
has
but-
been answered, that's why if your question has been answered, but if you have another one,
Yeah, I have another one.
okay,
Yeah.
sure.
My question is actually what makes it different here with defining death and difficulty with the reliance in medical profession purely versus other areas in tort, let's say medical malpractice or negligence, where you would rely quite heavily on the expertise of medical professionals. I just wonder your perspective on that.
No, and I'm not sure I have a good answer to that, or whether there should be, maybe death is like a broken arm. And if a medical professional comes in and says, look, the arm is broken, that's a matter of fact. I decide on a balance of probabilities that's the case, and that's the way it is. I guess the question is whether we think, and I tend to think that death is not just a medical, maybe that's just my own preferences, but it just because it has such a a fundamental meaning to people that it's a lot more than just a medical fact, but I mean, just because Justice Miller says that doesn't mean that it's true either, right? Because you could just as easily have a court like Justice Shaw who says, no, this is a medical fact and that's it. I just have to accept the fact. And me as a judge saying, oh, it's not a medical fact is not anymore true, really, you know, that's also a value laden thing to say. So I don't know that there's a good answer to that.
I have a question from Neil Lazar online. If there is room for a religious conscious objection and we don't want to interfere with the supply of organs for transplantation, is there room for a debate about discarding the dead donor rule and move towards a practice of organ donation following informed consent? Obviously, this would apply to terminally ill, dying patients. I mean, he's actually saying, Dr. Lazar is saying it would apply to terminally ill patients, but I participated in a conference in Belgium where a neurologist was talking about a patient who came to see him with a psychiatric illness who said, I want to die by organ donation. Like, this is my desire, you know, based on informed consent. So Dr. Lazar limits it to terminally ill patients, but would we have to debate this?
There's another connection to MAID, isn't there, right? I think there is an article about kind of death by or made by organ donation and how that works. I don't know, that's a pretty profound change too, to say that we discard the dead donor rule and I don't know, that's a slippery slope I'm not sure I want to go down, because especially with concerns that we have about medical assistance in dying now and people maybe consenting or seeking it out for reasons that may not be what the legislation originally intended, whether that's because they feel like a burden to their families or they can't get other support. So I guess I would worry about people saying, well, my life is not worth anything, please take my organs and yeah.
I think that's a really tough, reminds me that there's a movie starring Will Smith where he gives up all of his organs to save a bunch of people. So that's the real life example I come up with. But I haven't thought about this at all. One way into it might be to ask the following. So bioethicists and moral philosophers typically use these organ harvesting examples. Is it permissible to kill one person and harvest their organs to save 5 people? So the person's alive and you kill them. I think most people have the intuition that no, it's not permissible to do that. And then you just change it and say, what if they consent? What if they ask for it? I don't know if my intuition changes that much, to be honest. Now, some people might say the fact that they've consented to it and requested it makes all the difference and you ought to do it. But I don't think I share that intuition.
We have public policy kind of saying like you can't consent to certain, like you can't consent to cannibalism or something like that too, right? So I wonder if there are public policy kind of arguments there too.
I'll first go to Donna and then I'll come to you, okay? Donna,
Well, thank you so much for the presentation. I found it incredibly engaging and I think that I have more questions than answers too. But I have a really situated question based on my research. For the past 5 years, I have been researching on conscientious objection in healthcare, and I am conducting a comparative law study in which I analyze how all the countries in the world are regulating conscientious objection, and I'm trying to come out with the best regulatory practices. So something that I found so interesting was that many of the principles or constitutional arguments that we can identify in the literature and in the case law to justify conscientious objection in healthcare seems to apply equally well to the question of whether we should accommodate a religious exemption in the definition of death. And in that regard, I think that in addition to the right to religious freedom and the right to freedom of conscience and also moral pluralism, which I think that is a really good argument that you, Professor Sangiuliano, highlighted, I believe that the right to privacy and autonomy are also highly relevant. And these rights are ultimately will justify such accommodations. But
And here is like my questions and my concerns. Well, from my research, it seems that if these rights are strong enough to allow healthcare providers to refuse refuse a duty to provide care, then they might also be strong enough to justify a religious exemption to the neurological determination of death. I mean, if our legal system is allowing conscientious objection in healthcare based on these arguments, then to be consistent, it should also allow religious exemptions in cases like this. So my question will be if you are also, like, if you're also seeing that connection between conscientious objection and these kind of accommodations, and yeah, what is your perspective on that?
Do you have anything on this part?
Well, I think that maybe this goes back to the point I was saying before about like some of the debates here about accommodations to the legal definition of death, kind of, they do seem to stand or fall with related questions about conscientious objection to medical treatment, right? So at least in Ontario, it was decided that conscientious objection, there wouldn't be an accommodation for physicians when being asked for MAID, to make referrals for MAID. And so I don't know what the implication should be for that, but if for the sake of consistency, there wouldn't be an accommodation for the legal definition of death either. But you can go the opposite direction and say that both of those, like that, because we do want to have accommodations to the legal definition of death, that decision was wrongly decided. So I do think that there's this kind of coherence point that's important. And you can think of, I'm sure, a variety of other contexts where that's important. That coherence matters too.
Last question, Tristan. Okay, so let's take these two questions, maybe say briefly your question, and then we'll see what we can still answer in the remaining 5 minutes. Yes.
Oh, yeah, I just want to go back to the topic about, that we were discussing about like the dead donor role and like consenting to like die to have your organs, donated. How does, like, I know there's a huge focus on like bodily autonomy. And so it's just in like, what are your thoughts? Like, how do you balance bodily autonomy with someone who wants to like choose to die? Like at the end of the day, the outcome is death. So like, how does MAID, like getting MAID versus, like, I know if there's like a criteria to undergo MAID, but how does that differ from someone simply wanting to die to donate their organs?
And the second question.
Yeah, so it's actually related to what Donna asked, and actually also what I've read about the medical idea of consciousness related to animals. In some sort of way, I think that brain death and consciousness have some interrelation. So my question is actually whether we should think about more the medical idea of consciousness and how that relates to all the different discussions we have in the law with regard to animals, with regard to AI, with regard to unborn children, with regard to the death. And then I think there is an alternative group of scholars who think about going back to the basics of the law, which actually just defines what are moral interests not protected by law and interests protected by law. And then there's a definition of Blackstone, which is like very fundamental. An interest is any human desire or any object of human desire. And then I think a lot of discussions are going from the idea that, for example, if you talk about deceased people, and you talked about how family relatives have an interest in something, it's often debated that the deceased person has an interest, while actually the people remaining have an interest. And if we're talking about animals, it's very nice that they have rights, but they cannot go to court. So if you want to protect them, then you have regulations that regulate their interest. They have interest, of course, but not human desire. And I think, or this group of scholars, which are my colleagues and me, we think that there should be more debates, what you were referring to, like the unstructured moral values underlying charter rights. In Europe, for example, privacy is the most broad value that we have. Maybe it's time that legislators do not define that, because I think that's impossible, but they should start by defining what moral values they are actually protecting by legislation. And if they do, then there are clear distinctions between, for example, property rights and personality rights. Of course, they overlap in scope, but the underlying values are fundamentally different, and there can be some limitations. So how do you think about that? And how do you think that this overarching discussion that is going on in AI and children relate to each other?
Briefly.
Briefly, yeah, I don't know. Well, I think, I mean, I don't know, like this comes back to me into this idea, like what makes someone a moral member of our society? I think, I don't know that I have the answer to that, but I think there are conversations we have to have about what, you know, what is it just biological functioning, or is it something deeper? Is it kind of higher brain function, or is it, you know, that makes someone a member of our society that's,
That's.
I don't know, I don't have an answer
Yes,
to that, but I think that's a really, really good way of looking at it.
And Tristan's question, do you remember?
It was about kind of consenting to mate by organ donation, right?
Yeah, like how to balance bodily autonomy.
Yeah, well, and I mean, I guess it comes down to whether it's something we want to allow people to consent to, or whether we think that there are maybe risks or other harms that could occur if we start letting people consent to certain things. But I mean, a strong view of autonomy would say, like, it's my body, my choice, and if I decide that's how I want to go out, that's how I want to go out, right? If I can save 8 people with my organs, then.
So, do you want to say something, or you're fine?
I guess I'll just really quickly say that, like, one way of kind of investigating that question, which is a hard one, is like, what are other areas of law say about what people can and can't consent to? So some contracts are void for public policy. What does that mean? And you mentioned the example of what can you consent to as a sort of defense to criminal, when does consent count as a defense in assault in the criminal law? And do those kind of notions of autonomy kind of work their way here as well?
Yeah, so in the context of MAID, people forget that most, so unless you have a disease, illness, or disability, outside of the end of life context, you actually can't ask to be killed. So it's actually, so that's one of the big debates. You kind of single out a category of people who can be exempted from the criminal code that still prohibits consent to death or consent to be killed anyway. And finishing actually with a question which goes back to this discussion of the last couple of minutes. Nancy San Giuliano writes, should a subject who has opted for medically assisted death predefine their criteria of death? So yeah, so I mean, combining your idea that you may have to make religious exemptions for definitions of death with the idea of defining your death in order to do something to participate in medical assistance and die. We'll leave it at that. That was a very interesting conversation and a very interesting paper. So please join me in thanking our two speakers.